Swayam Prabha. Digital India. Educated India.
Hello friends, this is lecture number 17 under the course Law Relating to Women and Children. In this session, I have come up with the topic Protection of Widows' Rights in India. The women in our country has been subject of servitude, neglect, exploitation from very long period, and therefore it becomes important to discuss or to know about the rights of women in different aspects. The widows in India are not treated with respect and dignity. From very ancient time, the position of the widow woman has been very challenging because of the reasons that the women who become widow, they face various kinds of challenges like economic challenges. They also face the challenge of social exclusion. Reason being, there is the lack of knowledge about the rights of women, and also the region of social mindset or the established traditional thoughts about the neglect and dignity of women. The economic regions, the social regions, and one more region is responsible for such a vulnerable condition of women, that is the family bias and the lack of support. When a woman becomes widow, then it is left on its own. The family is not willing to support that woman, and therefore it becomes very difficult for such a woman who has become widow to survive or to face the different kind of challenges in her life. With this background or in this backdrop, this topic has been selected, the protection of widows' rights in India. Like the other lectures under this course, the discussion over the widows' rights is also divided into 4 parts: the introduction, the international mandate, constitutional mandate, and the legislative initiatives. United Nations declared 23rd June as International Widows Day since 2011 in the resolution number this, to bring attention to the plights of widows in mainstream of human rights. It seems that this is not the problem of only our country, or this is not the problem only of India, but this problem is being faced by the widows all over the world in all the countries, and therefore the international community has also been very cautious and careful about the rights of widows, and therefore from 2011 23rd June has been declared as International Widows Day, so that we can remember the plight of the women in the society and we can contribute to improve the situation about the protection of state of protection of the rights of widows. Widows have to face many challenges, from being able to get remarried to be able to adopt children. Society is not very welcoming towards widows. These are 2 important rights of a woman: right to marry, and if her husband dies or she becomes widow, or for any reason there is the dissolution of marriage, the condition of divorce is there, then a woman has the right to remarry. One more important aspect of the life of women to have the children, and therefore, the right to adoption is also very important right for women. But it has been observed that in India, elsewhere also, there was always the confusion about the right to remarry for the widows and right to adoption. The society was not very welcoming, even still the society is not very welcoming to give such rights to women, right to remarry and right to adoption. There are many challenges which are being faced by the widows. Number one, the economic challenges. Mostly non-working women after death of the husband are left financially worried and in peril to support themselves. It has been observed, we can see in the status of the widows in society, that if the woman who has become widow, if she is non-working, then there are always the problems for such a woman to survive or to face the challenges in her life. Such women are left on their own. There is no financial support from the side of the family, either it is the family of her own or the family of her husband. One more challenge which is being faced by the women who are widowed, that is the social exclusion, the problem or the challenge of social exclusion. After death of husband, widow is usually left isolated from many social gatherings, especially in rural areas. Still, even the present time, in this modern era, we see that in social gatherings, particularly in the religious ceremonies, in any such events in the house or in family, where any religious ceremony is being organized, the women are not allowed to participate in those ceremonies. It is thought that the widow women, they are not able to participate in ceremonies. So, this social stigma is a big challenge for the widow women. In India, social exclusion is very big challenge before the widow women in India, because the person or human being, they cannot lead their life without the social participation, without participation in the social ceremonies, social organizations or social gatherings. So, this right to participate in social gathering, it has also been, the women have also been deprived from this right to participate in social gathering. This is a big challenge in the life of the widow woman. One more challenge which is being faced by the women is who are widow, the unawareness about the rights of widows. The society as a whole and the widow women themselves, they are not aware of their rights. The society is not aware of the rights of the widows, and therefore, they do not permit the widow to remarry, to take the adoption or to participate in social gatherings. They are unaware the basic rights of women being the human being, that they are right to life and personal liberty, and this right to life and personal liberty includes the right to social participation. It is also important to note that right to equality is also very important or fundamental right, which is given to all the human beings. This is natural right, and the women cannot be discriminated on any ground, either they are married or they are widows. Social exclusion and unawareness about the rights of widows, these are the challenges being faced by the widows in our country, elsewhere also. One more challenge which is being faced by the women, that is the family bias, the lack of support. These are two very well connected issues or challenges which the women who are widow or widow women, they face. The family bias, we can see the family bias against the widows. The widows are neglected in the family, and the family members think that her husband dies because of her bad faith and his bad luck, and therefore, she is not deserving or she does not deserve to have the respect from all other family members. She is always neglected in the family exclusion or the family bias is the big challenge. The lack of support is also there. In-laws generally neglect the widows after the death of the husband, and it leads to her being alone and without any support from family and society. Sometimes we see that widows are neglected or they are isolated, or there is a family bias towards the widows because of the property rights also. The family members think that the widow should not be entitled to take partition of the family property. She should not take part in the family property, and it is also one reason to isolate the women or to have the bias towards the women. The international law relating to the rights of widows, it is very important to see that what is the international mandate, because this problem of the neglect to the rights of the widows is not confined to only one country. This is the global problem, and therefore, international community has been very careful about the rights of widows, and some international agreements or some international law has been developed to protect the rights of the women widows. The ILO Social Security Minimum Standards Convention 1952, that is the convention number 102. In international level organization, Social Security Minimum Standards Convention 1952, which is numbered as convention number 102. This convention is the result of General Conference of International Labour Organization to provide social security in employment not only to the employee, but also to his or her dependents, and therefore, this provision becomes relevant with regard to the protection of the rights of women. This provision is relevant because of the economic challenges which are being faced by the women because of the lack of financial resources for their life. This ILO convention grants the right to the widows, grants the right to the dependents of any person who was employee, and after his death the dependent should be given the rights, and therefore, this convention was made that social security should not be confined only to the life of the employee, but it should be extended to those also who are the dependent of the employee after the death of that employee. So, if any male employee during the employment, if any male employee gets dead, then it is the right of the widow of that employee to get the social security. Article 32 of this convention makes the provision for support of widows. It provides that if the death of a breadwinner is caused due to the accident or disease resulting from employment, widow or child is entitled to get support. Generally, this convention was agreed to by the international community, by the member states, to give the social security to the dependents of the employees after their death. And Article 32 makes the provision to provide for the social security to the widows and the children of any such employee if the death of the employee is caused because of the accident or the disease resulting from the employment, then widows or the child are entitled to get social security or social support. Article 36 of this convention provides for periodical payments to be made in case of incapacity to work, permanent loss of faculty, death of the breadwinner, and such payments and benefits in case of death of the breadwinner need to be made to widow and his children. This article 36 is also very significant provision of this convention, which provides for periodical payments, not the payment at one time at once, but the periodical, the continuous consistent payments to in case of incapacity of work. If any employee is not capable of doing the work for which he was employed, then the widow of that employee or the children or the child of that employee is entitled to get the support from the employment. Permanent loss of faculty. If there is any permanent loss of faculty of any breadwinner or the person who is the support for the family or who is responsible to financially support the family, then also the widows and the children should be made the periodical payments for their life, death of the breadwinner. So, these are the three grounds in this article 36, that if the incapacity of the work is caused, if the employee becomes incapable of doing the work for which he was employed. Number two, if there is any permanent loss of the faculty, any faculty of the employee, or the death of the employee is called who is the breadwinner for the family, then such payments and benefits should be given to the widow and the child of that employee, and these payments should be made periodically. One more provision in the convention is article 67, which also relates to the rights of the widows. Survivors of an employment fatality would render widow with 2 children 40% of the benefits as was in employment of the husband. The percentage of the support has also been fixed, that if the survivors of an employment fatality would render widow with 2 children 40% of the benefits. If the widow has the 2 children, then 40% benefits or the 40% of the earning which was being earned by the breadwinner of the family or the person who was in employment, then the widow should take the 40% part of that payment. So, we see that this convention of ILO, that is the ILO Social Security Minimum Standards Convention 1952, the convention number 102, it gives the rights or confers the rights, it recognizes the rights of the widows, and the social security is provided by this convention. State parties to this convention are expected to make the law in their countries, in their states, in accordance with the agreement made in the convention or in accordance with the commitment made by those countries in this convention. So, this convention may be a very strong initiative on the part of international community if it is adopted in its spirit by the state or the member countries to recognize the rights of the widows. Then Universal Declaration of Human Rights. In all the lectures, almost in all the lectures under the course of law relating to women and children, I have referred to the Universal Declaration of Human Rights. The UDHR or Universal Declaration of Human Rights, this is very basic document with regard to the protection of human rights of all the human beings. This UDHR or Universal Declaration of Human Rights was adopted by the General Assembly of United Nations in 1948 to recognize the basic rights, the human rights of the human being, on the justification that that each individual or each human being, each person has some basic rights, some natural rights, some inalienable rights, because of the fact that he or she is human being, and these rights are not conferred by any document that like constitution, or these rights are not conferred by the states or the governments. These rights are the natural rights, and all human beings, they are entitled to these rights from their very birth. So, as a person comes into existence, as a person takes the birth, he is entitled to these basic rights, human rights, natural rights, because these rights are provided by the nature itself, not by any government, not by any state. On the basis of this justification, on the basis of this thought, on the basis of this concept, the UDHR 1948 was adopted by the United Nations, and it becomes the basis of the protection of the basic human rights in the different countries. In India, we also see the part 3 of our constitution. These human rights may be called with various names, the several nomenclatures may be given to these basic rights or human rights. When these human rights are the part of any constitution, these are called as fundamental rights. So, therefore, this universal declaration of human rights is very basic source of all the rights of every person. Therefore, we are giving the reference, or we refer this universal declaration of human rights in almost all the lectures, because this is the source of each and every right of the human being. Therefore, it is also the source of the widow's rights. Article 25, clause 2 of Universal Declaration of Human Rights provides for equal social protection for all children, whether born in or out of wedlock. So, the children are protected by Article 25 2 of Universal Declaration of Human Rights. Whether these children are born in the wedlock or out of wedlock, all the children are protected, they are entitled to the basic human rights, because they are the human being. It also provides that widows who adopt children after the death of husband have to face many challenges, and such children also encounter many bias in the society. You can see the connection between this protection given to the children under Article 25 2 of Universal Declaration of Human Rights and the rights of widows. I told you that there are two important rights of the widows for their survival of the life after death of the husband. When they are left alone, when they are neglected, when they are socially excluded, when they are excluded with respect to the financial support, then two rights of widows become important. The widow must have the right to remarry, so that she can lead her raised life with the support of the husband or her partner. And number 2, if she is not willing, because this is the personal decision of any woman under Article 21, that whether she wants to marry or not, or whether she wants or she wishes to remarry or not. So, if the woman is not willing to remarry, then one more important right of the woman comes, and it is the right to have the children. When she does not have the children from her husband, then it becomes the challenge for the widow to adopt the children, because such adopted children by the widows, they are also not treated equally or with very due respect by the society. So, when Article 25 2 guarantees the basic human rights which are found in the Universal Declaration of Human Rights to those children who are born in the wedlock or who are born out of wedlock, or it means that the children who are adopted by any woman, by any person, are also entitled to these basic human rights falling in Universal Declaration of Human Rights, and therefore, it also recognizes the right of the widows to have the children or to adopt the children, and she also has the right of the social respect and the dignity to the children adopted by them. We see the international mandate by ILO convention, by Universal Declaration of Human Rights, recognizes the rights of women. What is the constitutional mandate or what are the constitutional provisions in Indian Constitution with regard to the protection of women? In this series, first comes Article 15, Clause 3. The Clause 3 of Article 15 provides that a state can formulate any provision with special focus on women and children. This clause is part of the fundamental rights. Article 15, which any state action that discriminates on the grounds only of religion, race, caste, sex, place of birth or any of them against any citizen, this Article 15 says that no such discrimination can be made. But Article 15(3) provides for the authority to the state to make the special laws, to take the special initiatives in favor of women and children. It means that Article 15, Clause 3 gives the mandate or the authority to the state to make the discriminatory provisions for the widows, to make the special law, to make the special provisions, to take the special initiatives with regard to the protection of widows' rights. But the vulnerable state of women and children was recognized by the Constitution, and therefore, the Constituent Assembly, despite the fact that Article 14 and Article 15, Clause 1 and Clause 2 negates any kind of discrimination on the basis of sex, the Constitutional Assembly, it was unanimous on the point that women and children should be given special attention by the state, and therefore, the state must be capable of making the provisions in favor of the women and children. Then comes Article 21. We know that Article 21 is the repository of the several fundamental rights. The Article 21 has been interpreted by the Supreme Court of India in different cases, in several cases, to include many more rights. The expansion of the term right to life and right to liberty has been made by the Supreme Court in such a way to include newer and newer rights within the scope, within the ambit of Article 21. Article 21, the Supreme Court in numerous cases decided that Article 21, that is right to life, have in its scope right to choose the spouse and even right to choose to marry or not. This right is prime source of the dignity and respect for widows in society. Article 21 gives the right to every person to make his or her own choices, and therefore, whether a person wants to marry or a person do not want to marry, this is the very basic right, personal right of that person, including the widows. Article 21 guarantees the right to remarry for the widows. Widows have the right to remarry under Article 21. Then we are to see the legislative initiatives. What are the legislative initiatives? These legislative initiatives may be divided in several classes, like what are the rights with regard to the property, what are the rights of the widows under Indian legislative regime with regard to the property, what are the rights of the widows with regard to the adoption, what are the rights of widows with regard to the maintenance, what are the rights of widows with regard to the marriage. These may be the different classes or the kinds of the rights of the widows, and what is the position or status of these rights of widows in Indian legal regime. We will see in this part of this lecture, that is the legislative initiatives on the part of Indian legislature to protect the rights of widows. Property rights after remarriage. If any widow remarries, then what are the property rights of such a widow? During British rule, Hindu widows got the right to remarry by the Hindu Widow Remarriage Act 1856. We know the history of this legislation. This legislation was enacted by the British government during the British regime as a result or as a consequence of several social movements in India for the protection of the rights of the widows. Two important social movements have been very significant in Indian history with regard to the rights of women. One, the social movement initiated by the Indian community or Indian social reformers for the protection of the rights of widows, particularly for recognizing the widow's right to remarry. And number two, the social movement for the prevention of eradication of the social vice, social menace, that is the sati pratha. Ishwar Chand Vidyasagar, Raja Ram Mohan Rai, these names are very significant with regard to these social movements. As the consequence of the social pressure created by the Indian society with regard to the protection of the rights of widows, this enactment, that is Hindu Widow Remarriage Act 1856, was enacted. But section 2 of this enactment implies that right in property of the deceased husband would lapse when the widow would remarry. If the widow remarries, then her right in the property of the husband would lapse. That was section 2 of the Hindu Widow Remarriage Act, and it reflects the social opinion or the social mindset at that time towards the widow woman. The families and the society was not willing to give the property rights to the widows after their remarriage. This act was repealed in 1983, and then the Hindu Widows Remarriage and Property Act 1989 was enacted. Hindu Widows Remarriage and Property Act 1989 replaces the Hindu Widow Remarriage Act 1856. By way of this enactment in the name of Hindu Widows Remarriage and Property Act 1989, the property right of the widows was recognized and it was restored, which was neglected by section 2 of Hindu Widow Remarriage Act 1956. The Hindu Widows Remarriage and Property Act 1989 came into effect and it restored the right of inheritance of widows of a deceased husband even after remarriage. So, now the Hindu widow has the right to remarry, and even after remarriage she has the right to property, right to inheritance in the property of the husband. Also, the Hindu Succession Act 1956 classified widows of Hindu male as class 1 here. The Hindu Succession Act 1956 was enacted to regulate the succession of the Hindu family, succession of the property in Hindu families. In this enactment, the different classes of heirs are specified, and Hindu widow has been placed as the class 1 heir. It granted property right to women over class 2 heirs. So, when Hindu widow, the widows of the Hindu male or a Hindu widow was made the class 1 heir, that means the Hindu Succession Act 1956 also recognizes the right to inheritance in the property of the husband. Then right of inheritance. See the right of inheritance. The succession and inheritance laws in India are primarily governed by religion. In different religions, the succession and inheritance rights are regulated by their own personal laws. Hindu Succession Act is there because the Hindu law has been codified. The succession inheritance in Muslims is governed by the Muslim personal law. So, all the communities, they govern the instances of inheritance and succession in accordance to their own personal laws. The succession and inheritance in Hindu, Buddhist, Jain, Sikhs are governed by Hindu Succession Act 1956. The act is equally applicable to both genders as well as on both movable and immovable property, and inconsiderate of the fact that a bill has been executed or not. Irrespective of the fact, inconsiderate of the fact that a bill has been executed or not, this enactment is equally applicable to both genders. It is equally applicable to both kinds of properties, movable properties and immovable properties. The property rights in India are governed by two schools of thoughts in Hindu law, that is the Mitakshara and Dayabhag. The former provides rights from birth and the later provide right in property on the basis of survivorship. See, there are two thoughts, Mitakshara, two systems of the property rights, and these property rights are governed by these two systems, by these thoughts. In Hindu law, these are the Mitakshara and Dayabhag. As I told you that Mitakshara system gives the right in property by birth, whereas the Dayabhag, it gives the right in property on the basis of survivorship. In case of ancestral property, where the right arises from birth, the person does not have complete authority over the ancestral property to transfer it on his will, because the survivorship arises from birth. But in case of self acquired property, it is on his will to transfer the property. So, this is the difference in the joint Hindu family property, that is the ancestral property, and the property which is acquired by a person by himself. So, the property which is ancestral property or which is the property of joint Hindu family, that cannot be transferred by any person who is entitled to have the right in that property by his or own will. Section 8 of Hindu Succession Act 1956 provides for general rule of succession in case of males, and according to the section, the property of male Hindu dying intestate devolves as per section 8A, which states that the property firstly will devolves in class 1 here, which includes the widow. Section 8 provides for the general rule for the succession of the property, and it says that the succession of the property will be made in accordance with section 8A. The section 8A states that the property firstly will devolves in class 1 here. As I told you that the widows have been placed as class 1 here in Hindu Succession Act. It means that the property firstly will devolve also to widows, when the widows are the class 1 here. Section 10 Rule 1 of the Act, which deals with the distribution of property among heirs in class 1 or the schedule states, and the class 1 of the schedule states that the widow of the deceased, or if there are more than one widows, all the widows together shall take one share. There may be the situation, widows are the class 1 here, and the property firstly devolves to class 1 here in accordance with Hindu Succession Act. So, the property will go firstly to widows also, but there may be more than one widows. When the Hindu Succession Act 1956 was enacted, when whole the Hindu law was codified, we know that there was no restriction on bigamy in Hindu community also. Bigamous marriages were being held in Hindu community also. The Hindu Marriage Act restricts or bars, prohibits the bigamy, and bigamy has been also declared to be offence. So, when Hindu Marriage Act prohibits the bigamy, that was the decade of 1950. At the same time, during the same years, the Hindu Succession Act was enacted, and therefore, there might be the possibility of more than one widows. Section 10 Rule 1 of the Act provides for such resolution of such a situation, how the property will devolve if there are more than one widows. This Rule 1 to Section 10 of the Act, it deals with the distribution of property among heirs in class 1. So, first rule is that the property shall go first on to the class 1 heirs. Within class 1 heirs, the widows are there, widows are the part of class 1 here, and therefore, the property first will devolve to widows also. But when there are more than one widows, then if there are more than one widows, all the widows together shall take one share. What does it mean? That suppose if after the life of the deceased, there are 4 survivors, 4 class 1 heirs, the widow may be there, 3 other class 1 heir may be there, and widows are in number 2, then there would be 4 shares of that property, and these 2 widows will get 1 share, meaning thereby that the widows as class 1 here will take one part of the property, and that one part of the property will further be divided if more than one widows are there. Widows are entitled only to one part of or one share of the property. There was one more problem in Hindu law with regard to the widow's rights. In joint Hindu family property, that is co-partitionary property, that co-partitionary property, in that co-partitionary property, there was no share of, there was no entitlement of the female survivors or the female members of the family. Only the male members of the family, they were entitled to have the share in the property of joint family. They had the right to take the part or the share of ancestral property. That was the big challenge, and it was also highlighted by the scholars that this is discrimination on the basis of sex in matters of succession and inheritance, because only the male members of the family are entitled to inherit or to succeed in the property of the joint Hindu family or the co-partitionary property, the females would not get any share. That was the big challenge. As we know that after the death of the husband, the women are neglected by the husband's family. They do not have any emotional relation or biological relation with such a widow, and therefore, they always try to deprive that widow from property rights. Many tactics have been applied by the husband's family to get rid of such a widow, and particularly when such a widow has a long time to live. She has become widow in early period of her marriage. Then the second option for the widow is the parent family, family of the father, where they can hope to live or to take the support. But after the death of the mothers and fathers in the family, the parent family or the family of the father and mother is also not very sensitive about the rights or towards the support to such widows. So, in such a situation, the widows, they have no support either from the husband's family or from the family of their fathers. And this rule of succession and inheritance of Hindu law, where the females were not the member of the Hindu family with respect to the rules of succession and inheritance of co-partitionary property. Ultimately, in 2005, the amendment was made in Hindu Succession Act 1956, and during this amendment in 2005, the daughters have become the co-partners by birth. When the daughters have become the co-partners by birth, now they are entitled to property rights, they are entitled to succession and inheritance in Hindu family equally with the male members of the family. This is also very significant development of Hindu law, when in 2005 the Hindu Succession Act was amended, that daughters, they also have the property right in co-partitionary property or in joint Hindu family property. Then the right of adoption, this is also very significant right in the life of widows. If widows have no support from the parents, from the family of the husband, they are neglected at both the places, then only hope or only the option for the widows is to adopt a child, particularly if that widow is not willing to remarry in her life. Section 8 of Hindu Adoption and Maintenance Act 1956 does not restrict a widow woman from adopting a child as long as she is a Hindu female who has attained the age of majority and is of sound mind. Section 8 of Hindu Adoption and Maintenance Act 1956 does not restrict a widow woman from adopting a child as long as she is Hindu female who has attained the age of majority and is of sound mind. There are three conditions which are to be fulfilled by a widow to adopt a child. The Hindu Adoption Maintenance Act, number 1, the Hindu Adoption Maintenance Act does not restrict the right of a widow to adopt a child. This is the general principle, meaning thereby that the Hindu Adoption and Maintenance Act 1956 recognizes the right of the widow to adopt a child, but this right of the widow to adopt the child is subject to three conditions. Number 1, that widow must be Hindu female. Number 2, that widow has attained the age of majority. Normally the age of majority is 18 years. And number 3, that Hindu widow is not of unsound mind. If these 3 conditions are fulfilled, the Hindu widow can adopt a child. It means that Hindu Adoption and Maintenance Act recognizes the right of the widows to adopt the children. Section 14, subsection 4 of the Act provides that a child adopted by a widow will get the legal status of stepson, stepdaughter when later the widow remarries. It also provides for the resolution of the problem, or it also clarifies the situation about the status of the children adopted by the widows if a widow after the adoption of a child decides or determines to remarry. When a widow after the adoption of child decides or determines to remarry, then that child adopted by the widow shall be treated as stepson or the stepdaughter. Under Christian and Muslim personal laws, the adoption right of the widow is not recognized, does not recognize the adoption. These personal laws do not recognize the concept of adoption. But section 56 of Juvenile Justice, Care and Protection of Children Act 2015 provides a secular framework to adoption laws, extending its purview to every Indian. In Hindu law, the widows are entitled to take the child by way of adoption. In the Christian law and Muslim personal law, the concept of adoption or the adoption is not recognized, and therefore, under the personal law of Christians and personal law of Muslims, it seems that widows are not entitled to adopt the child when the adoption itself is not recognized in these personal laws. In 2015, some amendments were made in the Juvenile Justice Act. The section 56, and it is renamed as the Juvenile Justice, Care and Protection of Children Act 2015. Section 56 of Juvenile Justice, Care and Protection of Children Act 2015 provides for a secular framework to adoption laws, extending its purview to every Indian irrespective of their own religion. So, this is the secular law which gives the right of adoption to every person, every individual irrespective of his or her religion. It means that under Juvenile Justice, Care and Protection of Children Act 2015, the women or the widows of any religion can take the adoption. The maintenance rights. Maintenance is also very significant aspect of the life of the widows, because the main challenge which is being faced by the widows is the lack of economic resources, the lack of financial resources for the support of their life. And therefore, the law of maintenance or the maintenance rights of the women become very significant. Section 19 of the Hindu Adoption and Maintenance Act 1956 deals with the maintenance of widowed daughter-in-law. This section states that if a Hindu widow is unable to obtain maintenance either from the estate of her husband, father, mother, son, daughter, or from their estates, she shall be entitled to be maintained by her father-in-law. So, the proper arrangement for the maintenance of the Hindu widow has been made in section 9 of Hindu Adoption and Maintenance Act. At first hand, the Hindu widow is entitled to take the maintenance from, obtain the maintenance from the estate of her husband. Then father, mother, son, daughter. But if she cannot obtain or she is unable to obtain the maintenance from the estate of his husband, father, son, daughter, mother, then the father-in-law is liable, he is obliged to provide for the maintenance to Hindu widow. Section 21(3) defines dependents including widow so long as she does not marry. The Hindu Adoption and Maintenance Act 1956, Section 21(3), it defines dependents including widow so long as she does not marry. So, if the widow is defined as the included as the dependent, then again she becomes entitled to the maintenance. Then the judicial approach is also important to be discussed with regard to the rights of the widows. What has been the approach of the judiciary? In the case of Sanjay Purushottam Patnakar versus Prajakta Pramod Patil 2015, the court held that widow women after remarriage have the right in the property of previous spouse's property as a class 1 here as per Hindu Succession Act. So, the property right as class 1 here was recognized by the Supreme Court of India, by the Bombay High Court in this case in 2015. Then in the case of Savanram versus Kalavanti, that was decided in 1967 by the Supreme Court, the court held that a Hindu woman, if adopts a son after the death of her husband, then the adopted son would be considered son of the deceased husband too. It means the adopted child of the widow has also been given the property rights. In Narayan versus Pushparanjan, the Kerala High Court has held that if a man dies leaving no spouse and children and have a half blood brother and a full blood sister, then the full blood sister will be rightful owner of the whole property of the deceased brother, barring the half blood brother. In 2015, this case, the Sabnam Hasmi case, was decided. The Supreme Court has allowed the right to adoption to Muslim women also under the Juvenile Justice Act, and said the act will over personal and religious codes of the country, and therefore, the Muslim widows are also entitled to take the right. Leela Gupta versus Lakshmi Narayan, 1978 Supreme Court, the Supreme Court has held that marriage in violation of section 5(3) does not render the marriage void, and the widow have the right to inherit the property of the deceased husband. These are the situation or the state of the rights of the widows in India. We have seen the legislative initiative, the international mandate, the constitutional mandate, the legislative initiatives and the judicial approach. And we have observed that what is the state of the rights of the widows. It seems that the sufficient legislative provisions have been made. The judicial approach has also been very positive towards the rights of the widows, but the social stigma or the social opinion about the widows is always hampering the rights of the widows, and therefore, it is imperative that the society should change its mindset towards the rights of widows, and widows should be respected, and their life and personal liberty, their right to dignity should also be respected. Thank you.